So we have breaking news in the Sean Diddy Combs federal prosecution case, and he is demanding full access to certain tapes as his trial comes near. His trial is set to start in May of 2025. And now Sean Diddy Combs, he has said this week that federal prosecutors are trampling on his trial preparation rights by limiting his access to what he calls exculpatory video evidence that supposedly will depict what he calls clearly consensual sex among willing adults rather than sex trafficking. Combs's lawyers made the arguments in the letter that you're seeing on the screen to U.S. District Judge Arun Subramanian, who is set to preside over Sean Diddy Combs' criminal trial in May. Prosecutors say that Combs used his vast media empire to traffic and abuse women, allegedly drugging victims and staging elaborate sexual performances dubbed, quote, freak-offs. Now, the defense argued on Tuesday of this week that those allegations are undermined by 9 videos in the government's possession, which will supposedly show Combs and one of the indictment's alleged victims having intercourse without any violence, coercion, threats, or manipulation whatsoever. Contrary to what the government has led this court and the public to believe, his defense team said, the so-called freak-offs were private sexual activity between fully consenting adults in a long-term relationship. These videos unambiguously show that the person alleged in the indictment to be victim number 1 not only consented, but thoroughly enjoyed herself. That's what Sean Combs' lawyers are claiming. The problem, Combs' lawyers said, is that the case's current protective order only allows the defense to watch these videos in the presence of law enforcement. Prosecutors insisted upon this unusual provision at the request of the victim in question, according to the letter that Sean Diddy Combs' lawyers submitted to the court. The Combs team said it needs its own copy of the tapes in order to analyze metadata and enhance the quality of the audio and lighting, as well as to create transcripts and exhibits for trial. Quote, unless the protective order is modified to require the government to produce copies of the videos, the defense will not be able to effectively make use of this critical evidence at trial, the defense team wrote. So this is going to be important to Sean Combs' case. And it's important to note that this has been going on ever since his arrest in September of 2024. And he's being held in Brooklyn in the Metropolitan Detention Center. We've covered that at length on this channel, and we've covered a lot of the important pleadings in this case. So we're going to go through now and look at the letter that Sean Combs' attorneys have sent now to the court, to the federal judge. And they said, we write on behalf of Sean Combs to request a modification of the terms of the protective order to require the government to electronically produce videos described in paragraphs 12A and 12C of the indictment. The protective order includes a novel provision making this video evidence available for inspection only and not electronically produced. So that's interesting. And I can understand why that as a defense attorney would be frustrating. If they're not actually producing you a copy of it, you can just inspect it. Sometimes they make it available. In this case, it seems like if law enforcement is present, they can go and view it in the presence of law enforcement, but they're not able to have their own analysts review it and enhance the lighting or enhance the audio to try to maybe get some more insight into what is going on in these videos. So they're saying that having reviewed these videos, it is now abundantly clear that they confirm Mr. Combs' innocence and that their full exculpatory value cannot be investigated and used unless they are electronically produced. Rule 16A1E expressly requires production of copies of such materials to the defense, and there is no plausible good cause to restrict access to them under Rule 16D1. Accordingly, they should be produced in the normal course so that the defense may evaluate and use them in the same manner as the other Rule 16 and Brady material. The 9 videos at issue are the so-called freak-off tapes with victim 1 that the government has repeatedly referenced, causing wild speculation in the media. Contrary to what the government has led this court and the public to believe, the so-called freak-offs were private sexual activity between fully consenting adults in a long-term relationship. Like many Americans in the privacy of their own bedrooms, they sometimes filmed their sexual activity. These videos unambiguously show that the person alleged in the indictment to be victim 1 not only consented, but thoroughly enjoyed herself. And then there's some redacted pieces of information that are blacked out. These recordings corroborate what witnesses have told the government, namely that victim 1, and then it has more redacted information. And then it says that there was certain information that was filed under seal. So there are certain, in court proceedings, it's important for you to understand that there are certain types of information that can be filed under seal that's not made available to the public. The recordings also directly refute the allegations that Mr. Combs kept these videos as, quote, collateral. These recordings were not on Mr. Combs' devices and were not seized from his homes. Rather, victim 1 kept these videos on her own device for years and produced them to the government herself. So the protective order issue here requires the parties to meet and confer about any dispute over the government's designations, after which the defense may seek a de-designation by the court. So we have conferred with the government counsel who opposed this request. So Diddy's counsel is saying, we want to have these tapes produced, these 9 videos that show the freak-offs. We believe that they will prove that Diddy is innocent. That's what his lawyers are saying. We believe that they will show that these sexual encounters were in fact fully consensual, willing sexual experiences between people in a long-term relationship. So next page, Diddy's lawyers state to the court, contrary to innumerable sensational media reports, the videos do not depict sex parties. There are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no minors, and not so much as a hint of coercion or violence. Far from the government's lurid descriptions, the videos show adults having consensual sex, plain and simple. At bottom, this case is about whether victim 1 was or was not a willing participant in her private sex life with Mr. Combs. The videos confirm that she plainly was. And then his attorneys give the factual background. They state that soon after Mr. Combs was charged, the parties began negotiating the terms of a protective order. During these negotiations, the government insisted, over defense objection, that certain videos obtained from victim 1 and depicting alleged freak-offs would not be electronically produced and would instead only be made available for in-person viewing while monitored by law enforcement. So Diddy's lawyers do not have their own copies of this, what they call exculpatory evidence. They have to go to a location where law enforcement is present and be supervised as they're watching these videos. The government explained that victim 1, whose attorney gave these videos to the government, requested that they not be produced to protect her privacy, and that the government would honor that request. To ensure that we would receive discovery without further delay, the defense agreed to receive the discovery under those conditions while reserving the right in the proposed order to later seek modification of designations from the court. On October 7, 2024, the court so ordered the proposed protective order. After spending 4 weeks attempting to schedule viewing of the evidence, the defense was finally able to watch the videos under the supervision of law enforcement on November 20th, 2024 and December 13th, 2024. The evidence consists of 9 videos depicting 6 unambiguously consensual sexual encounters, says Diddy's lawyers. In all 6 of these encounters, victim 1 is not only consenting, she is evidently happy, dominant, and completely in control. There is no evidence of any violence, coercion, threats, or manipulation whatsoever. There is no evidence that anyone is incapacitated or under the influence of drugs or excessive alcohol consumption. There is certainly no evidence of sex trafficking. There is certainly no evidence of sex trafficking, says Diddy's attorneys. The government also included for in-person inspection certain explicit photos that victim 1 sent to Mr. Combs. The government redacted these photographs from the copies of communications between victim 1 and Mr. Combs that were produced in discovery, even though such photographs do not fall within the scope of the protective order. These photographs also appear to reflect entirely consensual sexual activity. So on the next page of this complaint, and this is interesting, they're claiming this will prove that he's innocent. So on the next page of this letter, Diddy's attorneys then go on to state, Rule 16 requires the electronic production of these videos, specifically Rule 16A1E, provides that the government must permit the defendant to inspect and to copy data that is within the government's possession, custody, or control, and that is material to preparing the defense as direct evidence undermining the core of the government's case, because they're saying freak-off activity is the core of this case. His lawyers say these videos are unquestionably material. Evidence is material if it could be used to counter the government's case or to bolster a defense. The court's authority to enter or modify a protective order stems from Rule 16d1, which provides that at any time the court may, for good cause, deny, restrict, or defer discovery or inspection or grant other appropriate relief. So they're saying the court has basis to do this. A party can demonstrate good cause for the issuance of a protective order when a party shows that disclosure will result in a clearly defined, specific, and serious injury, such as compromising the privacy interests of innocent third parties, causing a risk of harm to law enforcement or others, or impeding ongoing government investigations. The government cannot meet its burden. There is no good cause to prevent the electronic production of these highly exculpatory videos. Because this case does not involve classified information or child pornography, there is no authority to restrict the defense counsel's possession, review, and analysis of the videos. So they're saying, hey, look, if the government is not going to freely produce these videos for us to have copies of, they need to show good cause, and here no good cause exists. They're saying there were no minors involved. It's not child pornography, and that they should be produced to the defense, because the defense would then be able to enhance the lighting or enhance the audio on the videos. They would be able to use them in their defense more effectively. So he's saying this is hindering my ability to prepare for trial. So the government cannot meet this burden. They're saying any concerns regarding victims' privacy interests are adequately protected by the remaining provisions of the protective order. There is no greater risk in granting defense counsel a copy of the files for the preparation of its defense under a suitable protective order than exists in the government's maintenance and use of the files in preparation of its own case. And that's a really interesting point that his lawyers are making. The government is free to use these videos for their own prosecution against Sean Diddy Combs. These videos are being used against him. And he's saying, well, hey, these have exculpatory value. These show that I'm innocent because they show that the victim was of age, she was consenting fully to the sexual activity, and that she was enjoying herself, etc., etc. That's what Diddy is claiming. And he's saying that he's at a disadvantage now in being able to prepare his defense because his attorneys are not allowed to have copies of these videos that the victim produced to the government. And she produced it from her own device that she has had on her device for years. And he's saying, Diddy is saying, I was in a long-term relationship with this person, and we engaged and we filmed ourselves, just like many other American couples film themselves in the bedroom. So this is really interesting, friends. This is heating up. Let's see what they said next. So on page 4 of this letter, Diddy's attorney said to the court, the argument is the government is free to designate the material as attorney's possession only, which would require that the material be maintained in a safe and secure manner by the defense counsel, shall not be possessed by the defendant himself, except in the presence of the defendant's counsel, and shall not be disclosed in any form, except pursuant to the terms of the protective order. So they're saying, hey, look, the court can still protect these videos and protect the privacy of this alleged victim. They could designate these tapes to be attorney's eyes only or attorney's possession only, so that Sean Combs himself does not get to have copies on his devices. That sounds reasonable. What do you think, friends? Let me know in the comments. Indeed, the attorney possession only designation is for the precise purpose of addressing potential risk to the privacy or safety of victims or witnesses and sufficiently mitigates any risk of exposure. Even if there were some remaining privacy concern, any hypothetical risk that the videos would be disclosed in contravention of this court's protective order is substantially outweighed by the real and substantial risk that Mr. Combs' defense will be hampered by limited access to the videos. Unless the protective order is modified to require the government to produce copies of the videos, the defense will not be able to effectively make use of this critical evidence at trial. The videos include audio recording, but much of it is inaudible on the device provided for inspection. And what is barely audible requires headphones to hear. On certain videos, the lighting is also very bad, and the images are quite dark and grainy. Mr. Combs needs to use defense experts, including experts who could enhance the quality of the video and audio and analyze the metadata associated with the videos, including when the videos were created and modified. And that's an important point, to look at the metadata, because remember, this alleged victim has had these videos stored on her devices for many years, and then as part of this federal prosecution, she just produced them to the government back in the fall of 2024. So what's to say that she didn't edit these in some way, or what's to say that these videos are in their purest form from when they were in fact taken? I agree with the defense attorneys that they have a right to have an expert, a forensic expert, look at these videos and decide what the metadata says and analyze it. I also agree that they should have the right to have a defendant enhance the audio, because if there are whispers on or quiet statements being made throughout the course of the alleged of this activity on the videos, and what if those comments are relevant? What if they're exculpatory? I mean, I tend to agree, and on this channel we don't take sides between parties, but I understand the defense counsel's point here. So moving along in this letter, these attorneys then state that the government has offered to use a neutral expert to enhance the audio and visual quality of the videos. This novel proposal is inconsistent with Rule 16 and the process, as it would restrict Mr. Combs from retaining and directing experts of his choosing and require him to unfairly preview his defense. It also does not account for the other ways Mr. Combs seeks to put the evidence to use. For example, Mr. Combs may need to show the recordings to other experts or witnesses consistent with the terms of the protective order. Mr. Combs will also need to extract portions of the videos to create trial exhibits, stills, and transcripts. all of these tasks will be impossible without obtaining copies of the video evidence. In some, there is a much greater likelihood that the defendant would be harmed in his ability to prepare a defense by limited access to the materials on the government's terms than there is that the materials will be further distributed by the defense in contravention of the court's order. Mr. Combs is entitled to put this evidence to use for trial. I tend to agree that I don't think that there's a lot of risk of the defense counsel distributing these videos. They don't want that heat. They don't want the heat of saying that they violated the court order or violated someone's privacy that's alleging to be a victim here. So, but I do see that there could be a lot of harm and prejudice in not allowing the defense attorneys to have the tapes. They should have the tapes. The prosecution has the tapes, and I think there should be parity. The defense should have the tapes as well, and put the appropriate provisions in the order to protect them as attorneys' possession only. So then it says Brady is a case that governs criminal evidence, also requires the government to produce copies of the videos. Under Brady, the government has a constitutional duty to disclose favorable evidence to the accused where such evidence is material either to guilt or to punishment. It requires production of information such that a defendant can take advantage of exculpatory evidence in time for its effective use at trial. So he's saying, hey, look, this has favorable evidence to me. The government should be producing this. So next, Diddy's attorneys go on to write, an item is material to preparing the defense under Rule 16 if it could be used to counter the government's case or bolster a defense. It is troubling that the government has had this evidence since December of 2023 and nonetheless brought these charges. Okay, so that's interesting. I didn't realize that before. Diddy's lawyers are saying that this alleged victim produced these videos to the government back in 2023, which is over a year ago, and that they nonetheless brought the charges against Sean Diddy Combs. They did that year-long investigation. They did ultimately arrest him in September of 2024, this past fall, and they charged him with racketeering. They charged him with sex trafficking in a federal prosecution. He's currently being held and detained in Brooklyn in Metropolitan Detention Center. Several judges have denied him bail. He has withdrawn his appeal on the bail issue, and he has accepted that he's going to be sitting in jail until his May 2025 trial. So the video evidence, the attorneys go on to state in the letter, the video evidence refutes the claim that victim one was forced to participate and can only be squared with her account if one assumes, as the government apparently does, that certain women cannot consent despite all indications to the contrary. So they're saying that these videos are incredibly important to Sean Combs' defense, to his trial, and that he really needs access, his counsel needs access to this. So then they refer to one of the bail appeal hearings, arguing that when women are motivated by the loss of their livelihood and housing or experience abuse outside freak-offs, they cannot consent, and that is sex trafficking. So they're saying that was the position of the government. The government's view also depends on the characterization of freak-offs as dirty, disgusting, or inherently unsavory, and therefore must have involved some amount of coercion. And they say, look at the indictment, describing freak-offs as elaborate and produced sex performances that were arranged, directed, and sometimes lasted multiple days. Multiple days. Wow, that's lengthy. Then they said, hey, look at referring to various freak-off supplies, including baby oil and lubricant. That would probably be standardly used in even consensual sex. I'm not sure what the relevance of that would be. The premise that freak-offs are inherently dangerous. They say that Diddy's lawyers are essentially pointing to different positions the government has taken. They say that bail appeal hearing at page 13 shows that the government seeks to police non-conforming sexual activity and that it assumes, despite all evidence to the contrary, that a woman's willing participation must have been coerced. So they're basically saying that the government is not giving enough credit to women. They're assuming that women cannot consent despite appearing as though they are consenting. So then Diddy's attorneys say any fair-minded viewer of the videos will quickly conclude that the prosecution of Mr. Combs is both sexist and puritanical. Oh, wow. Okay. It is sexist because the government's theory perpetuates stereotypes of female victimhood and lack of agency. The prosecution reflects a paternalistic view that the government is here to protect women who cannot be trusted to make their own decisions about sex and are not capable of consenting to sex that the prosecutors view as outside the norm. So they're saying, hey, look, these videos might show some examples of non-conforming sexual acts or some different types of sexual acts, but it's fully consensual and that you shouldn't be judging Diddy for engaging in this or judging. They're saying it shouldn't be judging Diddy or the women for having engaged in this. So then they state these videos depict clearly consensual sex among willing adults in a decades-long relationship and fundamentally undermine the government's case and victim one's claims. Indeed, they are entirely consistent with, and then it redacts some information, they're unquestionably Brady material despite the government's outlandish theories, and we anticipate that the undisclosed audio portions and metadata will contain Brady material as well. At a minimum, they are certainly not ultra-sensitive materials that need to be subject to extreme restrictions outside the normal course of discovery in criminal cases. Finally, preventing Mr. Combs' defense team from obtaining copies of the videos so he can prepare his defense at trial would violate the due process clause and his right to present a meaningful defense, his right to present a meaningful defense. So they're raising constitutional arguments in this regard now as well, and saying he's not going to be able to adequately prepare for his trial. Even interests as strong as the state secrets privilege, a much greater interest than the purported interest here, must, in certain cases, give way to a criminal defendant's right to present a meaningful defense. Because there is no good cause to restrict defense counsel's access to the videos, and because the videos must be disclosed pursuant to Brady and Rule 16, we respectfully request that the protective order be modified to require the government to electronically produce the videos of Mr. Combs and Victim 1 to Mr. Combs' counsel with the attorney's possession only designation under the protective order. Respectfully submitted, Mark Agnafilo and Anthony Rico and Alexandra Shapiro. Okay, so here we go, friends. This is going to be really interesting to see how it pans out, because this judge Arun Subramanian has ruled against Diddy on the bail issue. He denied Diddy's request for bail. He was very firm in saying that he, believes that this defendant, he believes that the government has satisfied their burden of showing that this defendant is a danger to the community. So it's going to be interesting how this court rules. It's going to be interesting to see how the government responds to this request and this demand by Diddy to have, unabridged, unrestricted access to these 9 videos that he says will prove his innocence, will help him defeat the government's claims against him, the charges. So let me know in the comments what you guys think. What do you think of his demand? I appreciate all of the comments that you guys have sent our way. I try to respond to each one of them. Thank you guys so much for all the interactive dialogue. You've got some really great points, by the way. You guys are really insightful. I come to you guys live each day to give you guys the celebrity legal news. So hit the subscribe button if you'd like to be notified of our upcoming streams. And we've been covering every aspect of the Sean Diddy Combs federal prosecution, including also the civil cases that have been filed against him. And we've covered all of the Tony Busby, Jay-Z, Quinn Emanuel drama that's going on because Jay-Z got pulled into one of these complaints that was filed by an anonymous alleged victim. Jay-Z was named a co-defendant with Sean Combs in one of the cases that Tony Busby is handling. So guys, let me know what you guys think, and I look forward to seeing you guys tomorrow on our next stream. Have a great night.